Good morning, everybody. My beloved advocate friends, junior advocates to whom this webinar series is dedicated to, and the senior advocates and judges who are present here. Lex Webinar Series is entering the 78th session today. Myself and Ms. Hemalatha advocate joined together in this gesture, and with the patronage of judges of Madras High Court, this has been going on steadily. And so far, we have conducted 77 sessions with very great resource persons like today's chief guest and a very important topic. And with nearly more than 5,800 subscribers and more than 1,89,000 views in the YouTube channel, we are taking strides from infancy to adulthood. I hope that the advocate community will be benefited because of this webinar series. And as of now, we have Honorable Mr. Justice T. Raja as today's resource person. A matter of pride is there for him because he hails from a district and studied in a panchayat school and studied in a college at Madurai, and he rose to this level because of his dint of hard work. Honorable Justice Raja was born on 25th day of May 1961 in a village called Thenur in Madurai district. He had his early school education till 8th standard only in a Panchayat Union school in Thenur village. And from 9th to 11th standard, he studied at Pasumale High School, Madurai. And he did his pre-university classes at Wakford College, Madurai. Thereafter, he had his BA degree at Madurai College, Madurai, and MA degree in social work at Madurai Institute of Social Work. And thereafter, he pursued his law at Madurai Law College. After enrollment in the Bar Council of Tamil Nadu on 22/6/1988, he started his law practice in the Madras High Court from June 98 onwards. And Justice Raja was associated as an advocate with Mr. C. Selvaraj, Senior Advocate, Madras High Court. After a bit of service in Madras High Court for nearly 2.5 years, Justice Raja has shifted his practice to the Honorable Supreme Court of India. And in New Delhi, he practiced not only in Supreme Court, and he also practiced before the High Court of Delhi, Central Administrative Tribunals, and Supreme Court of India. And he's practiced in civil, criminal, and constitutional and service matters. He served as the standing counsel for Dr. MGR Medical University for about 10 years before the Honorable Supreme Court. And he also served as the standing counsel for ESI before the Principal Bench, Central Administrative Tribunal, New Delhi, as well as in Delhi High Court and in the Supreme Court. He served as the standing counsel for Supreme Court Legal Service Authority, Society, for all civil and criminal matters for about 6 years. He was appointed as an additional Advocate General at Madurai Bench of Madras High Court from 9 to 2008, and he appeared in very important matters in Madurai Bench as an additional Advocate General. I fondly remember his association with him at Madurai Bench. And he was appointed as the additional judge of Madras High Court on 31/3/2009, and he was subsequently made the permanent judge. And Justice Raja is known for his landmark judgments in the Madras High Court and its principal seat at Madurai. With this warm and brief introduction, may I now request Justice T. Raja to start his deliberation on a very important topic of the day. It is relevant today as of now, the beauty of the Constitution of India and its Lacunae. Sir, you are most heartily welcome, and sir, the forum is yours.
Thank you. Good morning to all of you. It's indeed a great pleasure to take part in this free law webinar series organized by Mr. Srinivasa Raghavan and his students, to share some of my views on today's topic, Beauties of the Constitution of India and its Lacunae. I thank Mr. Srinivasa Raghavan and his students for taking so much of interest, concern on the members of the bar and enlightening them on various legal issues through this webinar series. In fact, this webinar series has been working as a continuous platform for the members of the bar to learn so many good things. Although we are all in the long lockdown, I wish him to continue his exercise for one single reason, that through this law webinar series, not only the members of the bar are going to get benefit, and the litigants, in the long run, the institution is also going to stand benefited from that. So I wish him all success in his endeavor. Friends, let us move on to the topic. World War II came to an end in Europe on 8th May 1945. Winston Churchill was the Prime Minister of England, the Great Britain, from 1940 to 1945. Since the Conservative Party was in power for 10 long years, King George VI dissolving the British Parliament after completing 10 long years in power by the Conservative parties, told all the political parties to face the general election. Finally, in the election held immediately, the Conservative Party, led by Winston Churchill, was very badly defeated. Mr. Clement Attlee, leader of the Labour Party, came to power. Then thereafter, after 1.5 years, Prime Minister of England announced to the entire world on 20th February 1947 that Great Britain would be granting freedom, independence to India soon. As promised, on 14th August 1947, Pakistan was granted independence. One day thereafter, on 15th August 1947, India was granted freedom, independence. But unfortunately, the great India was partitioned into two independent states. Now, India stands divided. When freedom was given to India, with a condition that India and Pakistan will continue to be dominion under European Convention. They said that till India comes forward with independent constitution, we will have to continue as a dominion. Therefore, our Indian Constituent Assembly had constituted a drafting committee headed by Dr. B.R. Ambedkar with 6 other members to draft the constitution. Taking almost 2 years, 11 months and 18 days, almost 3 long years, the drafting committee have completed the exercise, and then thereafter the draft constitution was placed before the public for their views and opinions, so that wherever anything, any infirmity is there, that can be rectified. Inviting the people's view in the domain of the people, the draft constitution was placed. After 6 months, we have received huge responses. After accepting the responses, again 2,000 amendments were made, and finally we had the constitution made to be. That we have solemnly adopted. We, the people of India, have adopted the Constitution of India on 26 November 1949. Therefore, we celebrate on 26 November 1940 every year Law Day. Although some of the provisions were brought into force, from the day we have adopted the Constitution on 26 November 1949, the, all provisions of the Constitution of India came into effect from 26 January 1950. Friends, we all know that Constitution of India is a supreme law of the land. It is a living document. It is a great instrument making the government system to work effectively and smoothly. It defines and also limits the powers of each organs of the government so that one organ will not step into another's field, causing unnecessary controversies. When the Constitution was made ready, it was having 395 articles in 22 parts with eight, eight schedules. When we grow up, as the Constitution being a living document, it also has to grow up with us. It has also grown up to 448 articles as of now in 25 parts with 5 appendices along with 12 schedules. And I must also mention one more thing, that as on today, the Parliament has made 103 amendments. When such a lengthy constitution was made, some of the people made some criticism, saying that it is one of the longest constitution in the world. In fact, when demand and claim for independence was made, Winston Churchill, the Prime Minister of Great Britain, he opposed the claim. He said that if India is granted independence, High Court, the power will go into the hands of rascals, rogues, freebooters. All Indian leaders will be of low caliber and men of straw. They will have sweet tongues and silly hearts. They will fight amongst themselves for power, and India will be lost in political squabbles. I unquote. Friends, two more criticisms have come from two other critics. One, Mr. Sir Ivor Jennings, who was then considered as a great constitutional expert in England. He also criticized Indian constitution, saying that it is too rigid and too long. And I must tell you that so far as the criticism made by Sir Ivor Jennings is concerned, and yet another criticism made by Mr. Anumandappa, who was also one of the members of the Constituent Assembly, who said that I was all the time waiting the music from the sitar and veena, but contrary thereto, I received and I'm hearing a music only from the old British bands. Friends, these are all the criticism will have to go as a pointless criticisms, legless to stand. I will explain in a few minutes, then we'll go into the topic. When the demand for freedom and independence was made by the Indian leaders, an unpalatable criticism was made not on the constitution but on the Indian leaders by Winston Churchill, who occupied held a position in the world. He was the Prime Minister of the Great Britain. He said that all Indian leaders will be of low caliber and men of straw. I must say, he was oblivious to the Indian history. He was oblivious to the British history. He was also oblivious to British India's history. I can tell you in few lines that you take India before Christ, India after Christ. Before Christ, if you go, you know Chanakya. As a student of law, you all people, some of the junior members, you must know that Jesus Christ was born 500 years after the death of Alexander the Great. When Alexander the Great became king at the age of 20, because his father Philip II was assassinated by one of his bodyguard. Therefore, he was immediately crowned. When his father was alive, they used to have some discussion on the world affairs. His father Philip told Alexander the Great, 150 years ago, the Persian king attempted to invade Macedonia. Therefore, we must go back and invade Macedonia. We must invade Persia. Persia was considered as the whole Asia. King Darius III was considered as the king of the king. Finally, this man, Alexander the Great, invaded Persia. And then after conquering almost all the countries, wherever he went, Turkey he conquered, Palestinian he conquered, Gaza he conquered. And then when he was keeping on conquering every country in Asia, Egypt came surrendering without even declaring war with them. And as a token of respect, they have handed over the key of the Egypt exchequer. Then he went further, came to Iran. Iraq conquered everything. When he came to Indian side, the Hydas Pass that was ruled by Indian king Porus, Purushottoman. He was not able to meet Purushottoman on the first 2 days war. Purushottoman was having 200, 300 war elephants. These Alexander's army was not able to meet. It is their own history that Alexander was defeated on the first day war. The second day war also he was not able to, his army was not able to meet the challenge put forth by Porus with 200 to 300 war elephants. And then what happened, he went into Afghanistan, battle. Today it is called as modern Afghanistan. Friends, we all know that even today, American army fitted and equipped with all sophisticated machines, all latest weaponry, has been camping for the past 16 long years in Afghanistan, but till date they are not able to bring one zone under their control, but Alexander the Great. Within few days, he has decimated the entire Afghanistan. He has completely obliterated the entire Afghanistan. And then by the time he had just kept his spies to go to India and study and find out the strength of the Indian kings. The spies came into India. They studied the situation. In the meanwhile, Chanakya, the royal advisor, the guiding light of Chandragupta Maurya kingdom, noticing that Alexander the Great would be definitely conquering India if they are standing and contesting on different platforms, he has unified all three dynasties. With his own statesmanship, he has brought all these three powers, three dynasties, Chandragupta Maurya dynasty, Nanda dynasty, and the Kalinga dynasty, to stand on one platform to challenge the invasion of Alexander the Great. The spies who went to study the strength of these Indian kings briefed Alexander the Great. They said that all three kings have joined together. They are not going to surrender. They are going to wage war against you. The reason is they got 6,000 war elephants. And they also said More than 1 lakh sepoys are there waiting for us to come and get killed. This message has spread like wildfire across the Alexander's army. Everybody came to know that when we are not able to challenge, we are not able to conquer lightly this forest with 200 to 300 war elephants, where is the question of meeting these three kings with 6,000 war elephants? They all, for the first time, revolted against Alexander the Great and said, we will not move even an inch. We have separated from the family for the last 12 long years. We want to go and see our motherland. We want to see our children. We want to see our family. With that, they said, no more war. Enough is enough. We'll go back. Then Alexander, for the first time, taking into account the objections placed by every army man, consulted his generals, captains. And then everybody stated that, yes, it is right on the part of the argument to say that it is very difficult to face the Indian kings because they have 6,000 war elephants and more than 1,000 lakh sepoys. For the first time in Indian history, in the world history, Alexander the Great accepted the rebellious response came from the army man, and he also said, yes, I also came out from Macedonia 12 years ago. We have conquered almost entire Asia. All right, we will go back. And he went back. Friends, the Alexander the Great was defeated. That is a record. It shows that all because of the statesmanship of Chanakya. It is before Christ. If we come after Christ, take the case of Aryabhatta, who was born in 478 AD. He was the first mathematician and 5th century astronomer. He only found Earth is round, and he said the Earth is orbiting on its own axis. As a result, the days and nights are taking place. The whole world has accepted it now. And he also further said that every 1 year is having 365 days, and 1 week is having 7 days. We have been following. The American, British citizens all over the world, this is the calendar we have been following. We are the leader. And then, if we again go back to the history, we take the case of Srinivasa Ramanujan, who was born in Europe in the year 1887, when there was no concept of black hole. He only said there is a black hole, the mathematician. He was taken to Cambridge University by one of the English professors, because that time India was British India, and he was made to study in the Cambridge University from 1914 till 1919, and then again he was taken to Trinity College. There he studied 1 year from 1919 to 1920. There he said there is a black hole. Today, Stephen Hawking has authored a book. We are all appreciating, keeping price on Stephen Hawking. But 100 years ago, when there was no any concept of black hole, Srinivasa Ramanujan, who has pinpointed that there is a black hole. What is a black hole? It is a space, it is a place in the space where a strong gravity is there. Even a minutest particle cannot penetrate into that. Even electromagnetic radiation such as light also cannot penetrate into that. And this has been used as one of the ground on which Srinivasa Ramanujan was knighted, and he was elected as a Fellow of Royal Society in the year 1920. Unfortunately, he passed away at a very early age of 32. Coming to the another generation, Sir C.V. Raman, who has discovered the molecular differentiation of light. He was awarded the highest Nobel Prize in the world in the year 1930 for physics. And again, just come down to the history, world history. We have the great leaders selfless sacrifices they made to the country for getting freedom. Mahatma Gandhi, Gopala Krishna Gokhale, Dr. Rajaram Mohan Roy, who has single-handedly abolished the service system. And then we have Chittaranjan, Lala Lajpat Rai. And then we have Rajaji, Jawaharlal Nehru, Motilal Nehru, Dr. Ambedkar, Subhash Chandra Bose. Under the chairmanship of Ambedkar, we have got the wonderful document today. We are discussing on the Constitution of India and its beauties. So therefore, the criticism made by Winston Churchill on Indian leaders, I say must go. Coming to the criticism made by Sir Ivor Jennings, he said the Indian Constitution is one of the longest and very rigid constitution. Friends, I must say, you take the case of American Constitution. It was adopted on 17th September 1787. Till date, 233 years have gone by. 27 amendments alone have been made so far. So from 1787 till 2000, the American constitutions underwent only 27 amendments. I could say at the rate of one amendment for 13 years. But we come to Indian Constitution to answer Sir Ivor Jennings' criticism that it is too long and too rigid. It cannot be too rigid. The reason is very simple. From 1949 or 1950, whatever the way you can calculate, till now, 70 years we have passed through. During the 70 years of time, we have amended the Constitution 103 times. The 103 times, the more amendments within this 70 years time stands as a proof of flexibility when you compare with the US Constitution that is 233 years old, which has undergone only 27 years. So therefore, if you just come to the rigidity, I must say that India is having so many diversification. You take the case of Tamil Nadu, we speak Tamil. You go to Kerala, Malayalam, Andhra, Telugu, Karnataka, Kannadam. And then if you go to Bengal, Bengali, Maharashtra, Marathi, Punjab, Punjabi, Kashmir, Kashmiri, when we have so much of diversity with us and so many religions, Hindu, Christian, Muslim, Parsi, so many, etc., etc. So we have to meet every individual, every state, almost 28 states today, 8 union territories we have, to meet out the requirement of the people, the basic need of the people. We have to have a long constitution. Therefore, the criticism made by Sir Ivor Jennings also have to go. Coming to Mr. Anamantappa's criticism on our constitution. He said, I'm hearing only music only from the British band. And he was in a way saying that we ought not to have borrowed some of the salient features from the world constitution. It cannot be correct for this reason. We were born as a newly born baby on 15th August 1947. Condition was put against us that you will continue to be a dominion until you make your own constitution. Therefore, we have to prepare our constitution. Almost they have taken 3 long years. And then the founding fathers of the constitution, having been completely satisfied, carried away by the parliament system of government from the United Kingdom, they have borrowed the parliamentary system of democracy. After borrowing this parliamentary form of government, we have been completely impressed by the Bill of Rights used by the American Constitution in their Constitution. We have borrowed the fundamental rights from the American Constitution. And after seeing that there is a separation of power, The one organ of a state cannot interfere into the field of another organ. We have copied the principles of separation of power, the doctrine of separation of power from the American Constitution. Then, if you come to the establishment of the Supreme Court, having been impressed, we again borrow from the American Constitution the establishment of the Supreme Court, and then we have borrowed that. Coming to the Ireland, the directive principle state policy, we have borrowed. More importantly, the concept of 5-year plan we have taken from the USSR. And then, above all, liberty, equality, and fraternity is more important thing for any man's existence. We have borrowed from the French Revolution. So therefore, it is meaningless to say that we should not borrow some important provisions from the world constitution. For this reason, I would say, when we have been using Thomas Alva Edison's invention, electric light and electric bulb, when we have been using the car invented by Carl Benz, when we have been using the telephone invented by Alexander Graham Bell, I don't think that borrowing some of the important provisions from the world constitution, we would be called, we are only back of borrowing. Friends, let us move on to the preamble of the Constitution. The preamble of the Constitution tells us very clearly that this is the main objectives of the Constitution. The Constitution makers have clearly made the objectives of the Constitution in the preamble unequivocally clear, stating that the people of India solemnly resolve to constitute India into a sovereign, socialist, secular, democratic, and republic, to secure to all its citizens justice, social, economic, and political, liberty of thought and expression, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and unity and integrity of the nation. So, after completing the Constitution, the main preamble has been prepared, and there the objectives of the Constitution has been made very clear. They said that we are adopting the Constitution into a sovereign. Sovereign means we have thrown out the foreign sovereignty and we have set up a sovereignty ourselves. Nobody can interfere with our domestic affairs. Socialist means a removal of inequalities in all walks of life. Secular, we all know that. In India, we don't give any importance to a particular religion. All religions are all treated equally. Coming to the democratic setup, it's more important for every man to have a free life. Democratic principles have been implanted in the preamble to say that every citizen in our country will have a say in the governance. Everybody can become, anyone can become in India president, prime minister, anyone can become an IAS officer, a civil servant. The reason is a democratic principle. It says that we have been guaranteed by the Constitution with so many special high-class guarantees. Therefore, the democratic principle has been implanted. Then we come to the republic. We are not under monarchy. In Britain, Queen is there, although they are a democratic country, But still, in India, we have elected representative. The president is elected once in 5 years. He may continue for another 5 years. But every 5 years, we are entitled to change our executive, chief executive. And that is the reflection of Republic principles. To secure to all its citizens social justice, social, economic, political, liberty of thought and expression. Ultimately, we have given to ourselves this, the great document. We will discuss about the other aspects of the objectives of the Constitution. We will move on to Article 1. Article 1, as a matter of fact, I must tell the young members of the bar that our Constitution tells India is having two names. India, that is Bharat. So India is having officially three names. One is India, that is Bharat 2, and secondly, we have Republic of India name. Moving on to Article 3, it gives us a very clear picture that the Parliament has got enormous power to make one state into three states. And if the Parliament thinks that two states can be made into one state, it can also do that. This is the power given to the Parliament. Coming to Article 5 of the Constitution, deals with the citizenship right, how to acquire. That is there till Article 11. And then if you come to Article 12, it defines what is state. State means government. State means legislature of each state, Parliament of India, local bodies, and other instrumental states. And if you go to Article 13, in fact, when we go into this Lacunae area, we will have a complete discussion on this Article 12, 13, and 368. But however, for the purpose of our future discussion, we have to know what is Article 12, what is Article 13, and what is Article 368. Article 13, subclass 1 says that all laws in force in the territory of India before the commencement of the Constitution, to the extent it is violating or contravening the rights conferred under Part 3 of the Constitution, shall be what? And then if you come down to Article 13.2, Article 13.2 says that the Parliament has made the Constitution, including Part 3. It tells every state government in Article 13.2 that the states, please, you do not have a power to make any law which will take away, which will abrogate or abridge any of the rights guaranteed in favor of the citizens under Part 3 of the Constitution of India. The second part also says that after warning the state of each state, saying that please do not make any law to take away or abridge the fundamental rights guaranteed under Part 3 of the Constitution, it also makes once again very clear in the second part of Article 13.2 that even if any state makes a law contravening any of the provisions or any of the rights conferred under Part 3, to the extent it is contravening, such law shall be what? And then we just come to Article 13.3. 13.3 says, defines what is law. Law means any rule, regulation, bylaw, culture, or usage having force of law in the territory of India will be law. So if you put together joint reading of Article 12, defining what is state, and then what is law that has been defined under Article 13.3, you will come to know for our future discussion whether law will include what you call the amendment of the Constitution. And then if the amendment of the Constitution has to be construed as a law, whether the Parliament under Article 368 of the Constitution can amend Part 3 of the Constitution. We will deal with it separately because it will take some time. Let us just have a primary look at other important articles so that we will be able to enjoy the beauties of the Constitution. Coming to Article 14, friends, I must tell you, Article 14 is not only a beauty of the Constitution, it may be one of the beauties of the Constitution, but it is one of the valuable ornaments, one of the valuable jewels that makes every Indian citizen proud of being part of this nation, great nation. Two reasons I can tell you. Article 14 says that the state shall not deny to any person equality before law and equal protection of law. And it also further says that the meaning of Article 14, you may belong to any religion, you may belong to any region, you may belong to any cause, any community, but the state shall not deny equality before law and equal protection of law. As I mentioned to you earlier, we have borrowed the parliamentary system of government from the Great Britain. Friends, we know that in India, anyone can become any lawyer. If he becomes a judge, he can become Chief Justice of India, irrespective of the fact whether he belongs to A religion, B religion, C religion, D religion. But if you go to UK, from where we have borrowed the parliamentary system of democracy, you must be surprised to know one very important aspect, that you may be a finest lawyer, but if he belongs to Roman Catholic, he cannot become Lord Chancellor in UK. Look at the pitiable state of affairs. But in India, as I mentioned to you, anyone can become Prime Minister. Anyone can contest the election if he is elected. Anyone can contest for MP election, MLA election. Anyone can get selected as, appointed as minister, and he can go up to the prime ministerial post or a chief ministerial post, or he can become a president. Similarly, a lawyer who is practicing, if he is becoming a judge, he can become a Chief Justice of India. Whether he belongs to East, West, or North, or whether he belongs to one religion or second religion, third religion, that's not a matter. But in the case of United Kingdom, the Great Britain, the finest lawyer, an extraordinarily brilliant lawyer, if he belongs to Roman Catholic, he can't become Lord Chancellor. That situation, that bad state of affairs continued till 2007, when Tony Blair became Prime Minister, and he only brought out an act called Removal of Disability Act. Only by virtue of this act, this disability has been removed. He can stay. He can just very, effortlessly he can come to the conclusion that India, having borrowed some special features of the British parliamentary system, we stand as a role model to the same Great Britain while following the equality class. We follow the equality class with great letter and spirit. You just go to American Constitution. Article 14 again comes into play, and it says that again India stands strong and taller than even American Constitution and American presidential system of government. For this reason, I've already mentioned, the American Constitution was enacted on 17 September 1787. 233 years have gone by. Friends, if you take the universal adult franchise that has been guaranteed, that has become one of the basic structure of our Constitution, that has been given in Article 326 to all people, whether you belong to, whether you are a lady or a gent, whether you are male or woman, but this right to vote to women was not given to American women for a period of 133 long years. From 1787 till 1920, American Constitution did not give the women franchise. No one was able to contest till 1920. No woman was able to cast their vote whenever the presidency elections were held. And only in the year 1920, when the 19th Amendment was made, the right to vote, women's suffrage was given, and only then people became equal. But we take the case of the Indian Constitution. On 26 November 1947, we have adopted the Constitution. From the day one we have adopted the Constitution, friends, we have guaranteed this universal adult franchise to all the people, irrespective of the fact whether you belong to A category, A religion, B religion, whether you are a woman or a male. But one more very interesting aspect I must also bring to notice. When the Constitution of India, through this Article 14, tells to the entire world that the equality class has to be followed, today India stands after some of the superpowers. We enjoy very prominent position in the world political history. We will deal with that subsequently, and then let us move on to Article 15. It is yet another beauties of the Constitution. Article 15 and Article 16. If you see Article 15.4 and Article 16.4, it gives a very peculiar rule. It says that the rule of reservation has been brought up. And this rule of reservation is not there anywhere in the world except in India. In the matters of employment, in the matters of admission, Article 16.4 says that the special provision can be made by the state government. Similarly, the parliament also can make a special provision for the purpose of removing the inequalities because of the slavery system, the untouchable problems we have perpetuated for ages, for centuries. The founding fathers thought fit that we have to make good the laws. Therefore, let us bring out this rule of reservation. In other countries, the rule of reservation is not there for the only reason that they do not practice the caste system in their country, but only in India we practice this caste system. Therefore, this rule of reservation has been brought into the Constitution. And I hope once this problem is taken out, this may come back to the original position. And then moving on to Article 17, deals with abolition of slavery and untouchability. Then we go to Article 19. Again, like Article 14, Article 19 of our Indian Constitution has to be mentioned that it is also one of the beauties of the Constitution. It gives us 7 freedoms originally when the Constitution was made. It has given us, it has guaranteed with high-class assurances the 7 freedoms. Article 19.1 says that all citizens shall have the right to freedom of speech and expression. Article 19.1b says all citizens shall have the right to assemble peacefully and without arms. C. All citizens shall have the right to form an association, form an union, including the property societies. B. All citizens shall have the right to move freely throughout the territory of India. All citizens shall have the right to reside and settle down in any parts of the India. And then Article 19.1e, right to move freely, and then right to hold, acquire, and dispose of the properties. Now this right has been dispensed with by the Janata government in the year 1979. Therefore, we are left with only 6 freedoms, and the last freedom is the right to carry on profession, trade, business throughout the territory of India. These fundamental rights coming under Part 3 cannot be seen anywhere in the world. It is there, but this type of guarantees, high-class guarantees, you cannot see anywhere. More particularly in the communist countries, you can't see. China, Burma, and other places, I don't think that you can enjoy these fundamental rights. They are not guaranteed. Coming to the fundamental rights, the beauty lies not in giving the high-class guarantee to these 6 basic rights, but the beauty lies in making all these basic rights, fundamental rights, as not absolute. It is not made absolute for the purpose of helping everyone to enjoy the fundamental rights. Secondly, the beauty lies in regulating these basic rights, fundamental rights, with the reasonable restrictions. So we must realize that the foresight, the vision of the founding fathers, giving these fundamental rights to each citizen, and then making it not absolute for the purpose of making every citizen to enjoy to the greater extent, and then making these rights regulated through reasonable restriction is really a great affair which nobody can ever imagine that. That is one of the greatest beauties of the Constitution. Coming to Article 20, it says that no person shall be convicted of any offense except for violation of the law. So you can't just convict anybody without having proved that he has violated the law. The second part of Article 20 says that no person shall be prosecuted, shall be convicted more than once for the same offense. See, these are all the formulas, the basic principle upon which a man can happily and safely live in this planet, in the part of this planet. Coming to Article 21, it guarantees the right to life, the right to life, and the right to personal liberties. We have seen that it is running into only one single line, but in due course, what happened due to the passage of time, both the High Courts and the Honorable Supreme Courts have expanded the scope of Article 21, and ultimately today the Indian citizens are enjoying more than 25 basic rights out of the interpretation made by the Supreme Court. Then coming on to Article 25 to 30, right to freedom of religion. In fact, the right to freedom of religion, I must say at the very outset, is yet another beauty of the Constitution. The reason being, again, if you go back to the communist countries, China, Burma, Sudan, even Pakistan, Saudi Arabia, and then other countries, this right to freedom of religion cannot be seen. But in India and in some other countries, we are enjoying this. If you come to Article 29 and 30, you'll be amazed to see how the minorities are all protected by the guarantees given to the Constitution. If a minority religious group wants to set up an education institution, they can have their own education institution, they can administer, they can they can they can have their own setup, and nobody is going to interfere with that. Similarly, the cultural rights are also preserved in Article 29. And then if you just come down to Article 32, moving to Supreme Court itself is guaranteed. Going to Supreme Court for the enforcement of the fundamental rights. Article 32 says that every citizen in our country is entitled to come to Supreme Court, nobody can prevent. And if he wants to come to Supreme Court, saying that the fundamental rights guaranteed under Part 3 of the Constitution have been violated, therefore it should be enforced, then they have a right to come to Supreme Court, Article 32. And then if you go to Part 4, Article 37, 37 says, none of the provisions under this part shall be enforced by any court of law. It says that these are all the principles. The states shall keep it in their mind while enacting the law. Article 37. So, Part 3 deals with the fundamental rights. Part 4 deals with the directive principles of state policy. The First Amendment, brought by Pandit Jawaharlal Nehru, to implement the directive principles of state policy through Article 31A capital, 31B capital, has really given a huge challenge, huge loggerhead between the judiciary and the parliament. And he said, Article 31A says that to implement the directive principles of state policy, that is for removal of inequalities, because if concentration of wealth is there at a few hands, it can be taken out and it can be distributed evenly to other persons. That is the motto, socialist principles. In the preamble, we have seen we have adopted the Constitution into a sovereign socialist. Now, how do we reach that end, that goal, unless we implement the directive principles of state policy? But Article 13.2 says that the state cannot make any law that will take away or abridge the rights guaranteed under Part 3. Under Part 3, then Article 19.1 will come into play. So if you say that I am going to implement the directive principles of state policy, violating the Article 19, the rights guaranteed under Article 19.1a, there is a class. Therefore, to avoid that class, Article 31A capital was brought in to the First Amendment, and they wanted to bring some land reforms. It was questioned before the several high courts, Patna High Court, Madhya Pradesh High Court, and Uttar Pradesh High Court. Fortunately, what happened? The Patna High Court has set aside, has struck down the validity of the Land Reforms Act, but other high courts have upheld the validity. That has given a big problem to the parliament. For the first time, they wanted to bring some important reforms, and it was the High Court has come as a biggest loggerhead on the way. Therefore, they do not want to wait till the Supreme Court pronounces judgment. They have brought up this Article 31A and 31B. 31B says that even if any court in our country interferes, strike down any law which has been made for the purpose of implementing the directive principles of state policy, then if the parliament puts that law into the 9th schedule, then the court cannot say that again still the law is invalid and it should be held as void. Article 31B. The matter was ultimately taken to Supreme Court. We all know that Sangari Prasad, after reading Article 12, what is stated, after reading Article 13.2 and 13.3, then Article 368 of the Constitution of India, that is amending power enjoyed by the Parliament, came to the conclusion that law does mean only ordinary law. Law does not mean amendment of the Constitution under Article 368. If the Parliament amends any part of the Constitution through the amending power by passing any amendment, the Supreme Court, the Honorable Five-Judge Bench said, amendment of the Constitution cannot be construed as a law. And then what happened? Subsequently, after 40 long years, the matter was again once again taken to the Supreme Court before another Constitution bench in Sir Johnson's case. In the Sir Johnson's case also, Supreme Court reiterating the stand taken by the earlier bench that the law does not mean the amendment of the Constitution, but the law does mean only the ordinary law. But it is very peculiar. It is very difficult to appreciate that. And now what happened? Once again, the matter was re-agitated. In 1967, before the Supreme Court in the famous Lacunae case, the Lacunae judgment with 11 judges bench ultimately said, after reading Article 12, reading Article 13.2, 13.3, and then Article 368, they said the interpretation given by the Supreme Court, namely in Sangari Prasad and also in Sir Johnson, they said they cannot be accepted. The law includes even amendment of the Constitution. As a result, Lacunae reversed the judgment given by the two constitutional bench, namely the judgments of the Supreme Court in that Sir Johnson's case was reversed, and also the judgments given by the Supreme Court in the Sangari Prasad case was also reversed, making it clear that the Parliament, you do not have a power. Although you have a power under Article 368 of the Constitution of India to make amendment, you cannot amend any part of any provisions under Part 3 of the Constitution. And they made it clear that from the date they are giving the judgment in the Lacunae, they said that from the day the judgment is given, the Parliament does not have a power to make any amendment in respect of Article, any part under Article 3 of the Constitution. Once again, the matter was taken to the 13 judges bench, Kesavananda Bharati, and the 13 judges bench said Lacunae was wrong. And they said, after analyzing that, the constituent power is something different and the legislative power is something different. And my suggestion would be here, when we think about the lacunae of the Indian Constitution, we all know that the basic principles when you make law, it should be unambiguous. But if you apply the principles, whether it is unambiguous or ambiguous, Article 13 has been made with lots of ambiguity. It should have been made very clear. In fact, when the Constitution was drafted, before it was brought into force, the founding fathers of our Constitution should have made a provision under Article 13 saying that law includes law made by the state legislatures, rules, regulations, bylaws, but any law to be made by the Parliament in exercise of the power given under Article 368 cannot be included under Article 13.3. But this has not been done. In fact, what happened, one of the members of the Constituent Assembly, Mr. Sandana, anticipating all these problems with great foresight, he has suggested to the Constituent Assembly to make a provision of Article 13, saying that the law does not include the amendment of the Constitution. Have they accepted it? In fact, what happened, they accepted it, but at the time of finalization, somehow they dropped this suggestion. As a result, today, of course, now Article 13, Subclass 4 has been brought up, amendment has been brought up, saying that Article 13.3 will not come in the way of making amendment in exercise of the power given under Article 368. But in the meanwhile, what happened? In view of the fact that yes, small clarity was lacking, the people were driven from pillar to post. There was a huge unpleasant situation between Parliament and judiciary. As a result, we have to go before the Sangari Prasad and also before the Supreme Court once again in the Sajjan's case, again the Kolaknath case, and then once again the Kesavananda Bharan case. See, my suggestion would be that had the makers of the Constitution, the founding fathers of the Constitution, accepted the suggestions given by Mr. Sandhanam to make a provision, perhaps the great deal of confusion could have been avoided. Then we will go on to the other provisions. Now, if you see Article 51, it deals with what we call the fundamental duties, friends. In fact, the fundamental duties given under Article 51A were not there at the time our constitution makers drafted the constitution. Yet another lacuna. What is the lacuna? When we have guaranteed the basic rights, fundamental rights in Article 19.1 and in Part 3, 14, and then 20, 21, they should have thought while that fundamental rights means then it should go along with the fundamental duties. What is fundamental duties? Article 51A says, every citizen should show some respect to the nation. Every citizen should respect the nation flag. And you should be ready to go on the render nation service whenever you are called upon to do so, more particularly if there is any foreign aggression. Every citizen has got a legal duty, a constitutional obligation to go on the render service. Otherwise, what will happen? They will come and subjugate once again. And these are the facts. And yet another fact is, a citizen, a person living in our country, not only here, everywhere, should have an obligation to protect and preserve the natural environment, like forests, water bodies, rivers. These are all the basic things. But unfortunately, what happened? The fundamental duties have been completely forgotten. After 27 long years, the fundamental duties have been brought into the Constitution. My only concern is, and only anxiety is, to tell the citizen that you must salute the national anthem. You must respect the national anthem. To salute the nation flag. To come forward for the purpose of rendering national service. Why did it take 27 long years? I can understand that there is human. The founding fathers were busy with drafting the constitution, but they had to complete the exercise. But at least after 1949, after 1950, it is our duty. We should have, like the First Amendment, we should have, even at least in the First Amendment, we should have brought up the fundamental duties. If it is there, had it been there, we would have really grown up now. Again, I just missed out Article 21A. 21A is another very interesting thing, but very sad affair, as I can say. Because we are all the members of the bar, we must also share very important things. When the fundamental rights are all framed, guaranteed with high-class promises to the people. We said, you are entitled to enjoy all these freedoms. I mentioned to you, all these 7 freedoms, it has been reduced to 6 freedoms. All citizens shall have the right to freedom of speech and expression, to move freely, to form association, to reside anywhere, and to carry on business, profession, occupation, etc. Now, and then Article 32 also says that every citizen is having right to move to Supreme Court. But how do you know and how you expect that the citizens will be able to enjoy all these freedoms without having the basic knowledge? So you should have the minimum educational standard to appreciate, to preserve these rights. My concern is right to education that has been brought into the Constitution in Article 21A in the year 2010. Look at it. Right to education has been made as one of the constitutional rights. When in the year 1977, after 27 years from the day we made the Constitution, see, unless a man knows what is my right, unless a man knows what is fundamental rights, unless a man knows what is how to move around, what is the reasonable restriction, whether it is absolute or not absolute, you should have minimum knowledge. Therefore, my view, my just feeling is the founding fathers in the Constitution. While I say that it is one of the greatest lacuna in the Constitution, I say that the founding fathers in the Constitution should have thought while even at the time of finalizing the Constitution, because they should have made the right to education, and they should have made this education as a compulsory right even long time back. Had they given this right to education as a compulsory right to be given by the state government, perhaps we would have really grown up taller than any other nation in social sphere, economic area, the scientific and technological field. In fact, we take the case of today affairs, the state of affairs. What is happening? When the social distancing has to be followed, so as to avoid escape from the COVID-19 pandemic, corona pandemic situation, people are all unnecessarily going and standing without mask before the wine shop. They are not given basic education even today. But had this right to education has been made compulsory in the year 1949, perhaps the corona would not have come to us. Today, the corona has been coming around the whole of us for the simple reason that we don't follow the social distancing. The reason is because many of us are illiterate. In India, still we have illiterate. The illiteracy problem would have been driven out long time back. This is one of the lacuna we have created. Of course, in 2010 we have rectified this lacuna, but had it been there, perhaps India would have really grown up as one of the superpowers in the world. Then moving on to Article 52. As a student of law, we can really enjoy by reading Article 52. It says, there shall be a president. There shall be a president. Look at it, how very carefully worded A. If you don't mention there shall be president, if you don't mention A, for example, I'm just visualizing situation. How these founding fathers have worked very carefully, very intelligently. For example, I'm saying A is missing. Unfortunately, government is facing coalition government. The country is facing the coalition government. 2-3 parties are all just going to form a government. Will they not say, you will have one president from your side, I will have another president from my side, the third man will also have another president from their side, but where they will sit? No, he can sit in north, one president can sit in north, another president can sit in south, another president can sit in east, and the fourth man can sit in west. To avoid all these possible confusion, future confusions, look at the foresight of the great founding fathers. He has made it very clear beyond anybody's suspicion or doubt that there shall be a president of India, so that there cannot be one more president. And then if you come down to Article 53(1), it says that the president shall be vested with the executive power. And then Article 53, so clause 2 says that the supreme command of the armed forces of the Union shall be vested with the president, and the powers thereof shall be regulated by law. I'll just come to that point. And then if you move on to Article 56, it says the term of office for the president shall be 5 years from the date he enters upon his office. Now, I would like to make it clear that look at again the extraordinary, the ability which they showed, the acumen which they showed when drafting the Constitution. That is, I would say, in my view, it is one of the beauties of the Constitution. When the president has been given the executive power and also vested with the supreme command of armed forces of the Union. Article 56 says the term is only 5 years. Today, we have a very peculiar situation. The corona is there. We are not able to come out. For example, I am the president of India. I say, Speaker, Parliament Speaker, and the opposition leader, please come here. Today, we are not able to do any work for the last 6 months or 1 year. Because of the corona, we are not able to do our obligation. Therefore, let us extend our term of office from 5 years to 6 years by exercising the power, the executive powers, and also the supreme command of the armed forces of the Union. Can you do so? Maybe a question, but the answer would be, it is not possible. The reason is Article 326 will come in to rescue this problem, saying that Article 326 guarantees the universal adult franchise to everyone. The universal adult franchise has been accepted as the basic structure of the Constitution. Once the universal adult franchise has been accepted as the basic structure of the Constitution, every citizen shall have a right to cast his vote in every 5 years. So if you get extended your term of office, that right, that basic rights would be breached. Therefore, it is not permissible. I would say that every article, every effort, and everywhere the Constitution makers, the creator of the Constitution, have shown their exemplary skills. And these are all the examples. Now let us come to Article 78. I just tell you for only small reasons. I hope I'm just taking more time, Mr.
No, sir, time is not the constraint, sir. You are at liberty to take more time.
Okay. I will try to complete it now as far as possible now. Now, if you just come to Article 78, there is a meaning in that. Therefore, I want to just indicate some of the provisions. At least the superficially, let us discuss about that. If not, going very deep into this matter. Article 78. 78 tells Honorable Prime Minister, it shall be the duty of the Prime Minister to go and communicate to the President all the decisions taken in the Council of Ministers and the proposed legislation is going to be placed before the Parliament. Look at the order placed by the Constitution of India on everyone. See, after vesting the power on the President, saying that you are the executive, you are the chief executive, they said Article 53, clause 2 says that the power thereof shall be regulated by law. You can't do anything else. For example, I'm just visualizing a situation that, see, I'm just getting 5 lakh rupees per month as a President of India. But a person, an engineer who is graduating from the IIT Madras, IIT Delhi, he is just going and joining in multinational company. Within a few months, he is getting 10 lakh rupees. Be a president, if I say that Governor of Reserve Bank, please come. Now, I am the president, I am enjoying the executive powers of the nation, and I am also enjoying the supreme command of the nation, armed forces, but I am given only 5 lakh rupees, we are going to double it. It can't be done. And the Constitution tells everywhere, it makes sure that nowhere any untoward incident takes place. And this is how the articles have been so carefully worded. And if you see Article 78, it tells that it goes like this. It shall be the duty of the Prime Minister of India to go and communicate to the President of India the decision taken in the Council of Ministers. And not only that, he should also go and brief the President of India every now and then about the proposed amendments going to be made. In case some unconscionable proposals are going to be, legislations are going to be made, the President can intervene and to say that it is not possible, I will not agree, please don't do that. So therefore, to avoid any contingencies in future, Article 78 is imposing duties on the Prime Minister. And then we come to Article 79. Friends, as a student of law, it says, very important article, very interesting article. I must say, more than beauty, it is very, very important for more particularly the lawyers. There shall be a parliament. Look at it. Look how the Constitution creates parliament. There shall be a parliament. Look at it. It's not, the A is not missing, A is there. Otherwise, what will happen? There can be one more parliament. That has been ruled out completely now. It says that there shall be a parliament consisting of a president with two houses, namely the House of the Councils and the House of the People. So you can't escape. You can't try to bring anything inside. And then, see, a question is always asked whether Parliament is supreme or the Constitution is supreme. Many times we have come across, many people say that the Parliament is supreme because they are exercising all the powers. I have already mentioned that in Kolak North, it has been made clear that it is only Constitution which is supreme. And to get it further confirmed, this is the article. Article 79 deals very carefully and clearly without leaving any doubt whatsoever to anyone to say that it is not. I would say that Article 71 saying that there shall be a parliament, it is showing that the Constitution is a source of power to the parliament. Because without Article 79, the parliament would not have come into. So therefore, the Constitution in my reading would be the supreme. And then if we move on to article, when we talk about this Article 78, there is an equivalent article. It also tells the Chief Minister under Article 167. The article says that the Chief Minister also has a duty. It shall be the duty of Chief Minister to go and communicate to the governor of each state the decision taken in the Council of Ministers and also the proposed legislation going to be placed before the Assembly. And then therefore nobody is left out from their obligations. And then if you come to Article 86 and 87, very interesting article if you see that. 86 says, and 86 and 87, they are dealing with the right of the President to address the Parliament. Look at it. Parliament can be addressed. If you read Article 86 and 87, 86 says that the President may address when any bill is pending. He may address, he may summon the Parliament and then he can come and address. Friends, from day one till now, no President exercising the power under Article 86 has addressed the Parliament because it says you may. But here is a case, if you move on to Article 87, the President shall address. Look at it now. Constitution tells, see, you have to do it, then you have to do it. Then how many times you can do it? It also mentions how many times. It says Article 87, if you see, the right of the President to address the Parliament. It says that the President shall address at the commencement of the first session after each general election. First one, the President shall address the both houses of the Parliament at the commencement of the first session of each year. That's all. If I'm President, for example, I want to visit the Parliament every month. Is it possible under Article 87? Possible. Whether it is possible under Article 86, only in a case where the bill is pending. In respect of the building, if he wants to address, telling the people that you do this, you don't do this, the parliament will be waiting for you. And if you want to visit every week or every month or every now and then, Constitution does not permit. Look at the checks, look at the balance, how it has been created against everyone. Nobody can take the law in their own hands. Everybody is below the law. Everybody has go with the dictum given by the Constitution. And then if you come to Article 105, it gives immunities to the members of the parliament, saying that if when you are debating in the parliament, you may be exceeding your limit. Therefore, Article 105, look at the founding fathers' ability. They said that if anything is spoken, anything is set in the parliament, the exercise of the powers and duties as a member of parliament, they are not liable for any criminal proceedings. It is good. It must be there. And rightly it has been done so. Otherwise, what will happen? The opposition leader, he will say that this man is speaking too much. All the time he is making a question which I am not able to answer. See, file a case against him. And this gentleman will be all the time running from one court to another court, and then he will not be able to find time to come to parliament to take part in the proceedings. So therefore, Article 105 gives complete immunity to members of the parliament. Then, when you move on to Article 145, friends, Constitution tells the president to behave in a way. Constitution tells the Honorable Prime Minister to do a particular things in a particular way. It does not leave even the Supreme Court. It tells the Supreme Court. It's very important for the members of the bar to know that. Article 145 says, Supreme Court, if you come across a substantial question of law as to the interpretation of Constitution comes to you, please keep it in mind that that substantial question of law as to the interpretation of the Constitution shall be answered by 5 members, 5 wise men. Please do not answer by 1. Please do not answer by 2 division bench. Do not answer by 3. That is not enough. You must answer. You must sit together with the 5 wise men and answer that. Friends, the message today you have to carry is this. When you are drafting a plight, or a drafting a written statement, or a drafting an appeal, or drafting a writ petition, or a appeal, or a counter rejoinder, you must all the time in your lifetime can't forget that you must ensure that every pleadings, whether it is, as I mentioned, plaint or written statement or counter or appeal or whichever the ground, you must ensure that the pleading should carry the substantial question of law rising to public importance, or substantial question of law as to the interpretation of the Constitution. That should be there so that if at least you are not able to get any relief from one court, at least in the Supreme Court, they will say, yeah, this is a case where the substantial question of law as to the personal Constitution of India has been raised. Therefore, we will refer to the Constitution bench. The Constitution bench will sit and the 5 wise men will answer the question. As a result, you may get your problems, grievances redressed. Therefore, please take home that when you are drafting, see that the substantial question of law as to the interpretation of the Constitution is there in your pleadings. That is one thing. And again, it says that Article 145, it is not sparing anybody. And it is telling that it is your duty, Please don't take very, lightly. Take it seriously. That is what the Constitution has been telling. And it says that whenever the President of India is sending any queries, seeking your advice, the Honorable Supreme Court, please, you all people sit in 5 and then please answer that. So whenever there is a reference coming from the President of India under the advisory jurisdiction, you people will have to sit together in 5 and then answer the question. So what I want to make it clear is, see, the Constitution does not spare anybody. Everywhere it is just giving. Everywhere. See, nobody can be spared from discharging their obligations. And then if you just come to Article 245, very interesting article. I must say, another beauties in the Constitution. We have, generally we will say that the state means they can make law within the local limits, within the territorial limits. They cannot make beyond the limit. The Kerala government cannot make any law touching the people sitting in Nagarkoil, or the Tamil Nadu government cannot make any law affecting somebody who is sitting in Kozhikode. Similarly, the union, the parliament can make law within the four corners if it is falling within list 1. If it is list 2, the state can make it within their jurisdiction. And then if it is concurrent list, then both can join together and you can make it now. But the question is, the academic question is, the very important question is, if something happens outside the jurisdiction of territorial jurisdiction limits of India, where we will go? Then can we say that India, the parliament, does not have the power? If you go to Article 1, entry 21, it says that your vessel, Indian vessel, is going beyond the territorial limit. A piracy takes place. Some pirates comes and they are attacking, robbing everybody. All your cargo, valuable things are being completely robbed. If there is a nexus with the acts done over there with your country, then Article 245 plus 2 says that Parliament has got power to make law even beyond the territorial jurisdiction. For example, as I mentioned to you, in the beyond the territorial limit, anything happens, Parliament has got power. Similarly, in the mid-year, flight has taken off from Los Angeles, comes to India. It has completely gone out of the territorial limit of United States of America, and there is no territorial limit of India. But in the mid-air, somebody is attacking somebody, and then the Indian is, as a result, second to injury. If the Indian, because if there is a nexus with your nation, and then you have the power to make law. That will have a power jurisdiction even beyond the territorial limit. Again, very interesting aspect is if you see list 1, entry 8, it gives enormous power to the CBI. You take the case of the present problem going in Maharashtra and Bihar. One famous actor, Sushant, he died. He came from Bihar, and he was doing his acting role. He was one of the reputed film actor, but he died all of a sudden. Allegation was his girlfriend poison. Allegation. Now the Maharashtra government is undertaking the investigation. Maharashtra police is undertaking the investigation. The Bihar police wants to have their own investigation. They want to go into their own the issues, and they are also doing it. Then the Maharashtra government said that the Maharashtra police alone will have jurisdiction. Then the Bihar government said that no, Bihar police, because it is my man. He has come from here and he was settled down. He was carrying on his work. Now the CBI comes into picture. If you see list 1, entry 8, if there is a clash between the state police and the CBI, the state police should yield to the CBI. Now the CBI has taken up the matter, and then neither the Maharashtra state police or the Bihar state police can create anything. They will impartially do the work. See, with that view in mind, this Article 245 subclass 2 has been made. Moving on to the next article, 247. One of the very interesting article. It says that the Parliament has got power to create more additional courts. Whenever the laws made by the Parliament making certain offences is punishable vigorously has not been taken care of by the state government, then the parliament has got the power to create more additional courts. It says that Article 247 says that if any law is made by the parliament and if that law is not properly followed, it says that we will take over the expenditure of the judge. We will take over the established expenditure. And I can cite one example, post-POCSO. A minor girl is raped and victimized. Now, if that minor girl who is a victim has not seen the light of justice for quite a long time, what will happen? After 5 years, after 10 years, the matter is taken up. People will lose their memory. The child also will lose the memory, what will happen in all these things. To preserve, to bring home the offender to justice, before the justice. This Article 247 says that a special courts can be created. As a result, what happened today, in every district we have a special courts, POCSO court, dealing with the POCSO offences. Within 1 year or 2 years, we are able to see that the cases registered under the POCSO Act are all completely given clearance, completely disposed of. So, and then if you move on to Article 257, controlling power, I will just cut short it now. The controlling power of the union over the state. You take the case of in Tamil Nadu. In Tamil Nadu, all the time we are fighting with the Karnataka government for Kaveri water. On one side, we are fighting with the Kerala government for preserving the Mullai Periyar Dam. They say that all the time they are posing a threat that any time this Mullai Periyar Dam will collapse. As a result, the water will come and take away, wash away most of the people. The water is more important. If you are demolishing, then where will go? All the 5, 6 districts will be completely become desert. It is the argument. Every time the state government is fighting with the 2 state governments. Now the parliament comes into picture. Let us resolve this problem once and for all. They have studied the situation and then they have come to the point. Yes, these 3 state governments are all unnecessarily fighting for water. What we do, see, there is a river called Godavari just running in the neighboring state, Andhra. What we do, the Godavari every year is draining minimum 3,000 TMC of water into the Bay of Bengal. Last year, 2 years back, 5,000 TMC of water have been drained into this Bay of Bengal. So the Union of India comes into picture and they say, why this water is unnecessarily, wastefully drained into this Bay of Bengal? What we will do? We will do this way. We will make a national waterways taking the excess water, for example, 1,500 TMC of water from Kaveri and then connecting Pala, connecting Kaveri, connecting Vaigai, then connecting Tabrabarni. We will take the water again to Kerala. We will give it to them. If there is a scheme or a plan brought out, as a result, for the purpose of making the national waterways, the lands are to be acquired. The state government cannot come on the way. If they are coming and blocking the road, then they exercise their emergency power. And then as a result, they can ensure that the scheme is properly ensured. Friends, whether you believe it or not, there is a provision. Our forefathers have given a will. When there is a will, there is a way. So this provision, hope, I trust and hope that one day is going to come as a reality, and the credit will go to the Free Law Webinar Series only. Coming to Article 261 sub class 3, again, it is going to be a message to the members of the bar. See, we all the time we say if there is any degree or final order passed by one competent civil courts in Calcutta against a judgment in Tamil Nadu, the question always arises: how can you execute this order, degree? Article 261 sub clause 3 makes it absolutely clear that if any degree or a final order is made by any competent civil court anywhere within the territory of India, it is quite capable of execution in any part of the world. Similarly, therefore I say, if one order degree is passed in Calcutta and that degree is sent to you here in Tamil Nadu against a judgment who is residing here, it is always executable. And you need not refer to any other High Court judgment, Supreme Court judgment. you can simply refer to Article 261, Subclause 3, saying that it is a constitutional right. Once you bring to the notice of the court that it is a constitutional right, under Article 261, Subclause 3, that degree has to be executed, it can be easily executed. Therefore, kindly make use of this provision 261, Subclause 3 as a constitutional argument, and no court will ignore it also. Moving on to Article 301. 301 is nothing but is similar, is synonymous to Article 19(1)(g), the right to carry on business, the right to carry on trade, business all over the territory of India. And then coming to Article 311. 311 is nothing but it is a base, it is a foundation for the service jurisprudence to come up. It simply says that a government servant, whether you are a state government servant or a central government, you are in central service, your services cannot be terminated without there being any inquiry, without giving an opportunity. So everything, this entire service prudence have come up only from this Article 311. Coming to Article 317. I'm just mentioning these are all the beauties of the Constitution. And then see, without Article 311, no government servant working in state government or central government or all India service can be able to complete it only, because it is giving huge protection to the person who is holding civil post, either in the state government or central government or all India service now. Then coming to Article 317, it also protects the office of the chairmanship and the membership of the Public Service Commission. Once you are appointed, then even the president cannot dismiss you from service. The reason is, see, today the executives may interfere with the powers of the chairman and the members of the Union Public Service Commission in the case of appointment of IPS officer, IAS officer, or any other top post. They may say that you are fine, the list of persons are given, please do that, otherwise I will dismiss you from service. Today, to safeguard that position, to ensure that meritorious candidates are all appointed, and to avoid corruption, nepotism, this Article 317 has been brought into. And then if you see Article 324, friends, you please read Article 324. I do not want to waste your time because we have already consumed so much of time. 324 makes everybody into surprise. I have already mentioned that the president is enjoying the executive power under Article 53(1). 53(2) also is enjoying the supreme command of the armed force of the Union. And then the person is exercising the judicial power. Whenever anybody is convicted, then the mercy petition comes, he can entertain, he can allow it, setting at naught all the judgments of the lower courts. But if Article 324 comes into play, the great man goes down, and then the election commission comes up. The election commission comes and tells, if they will not come personally, they will just write a letter to the President of India or to the governor in respect of holding by-elections. Once the Chief Election Commission writes a letter making a request to the President of India, now the time has come to hold general election to the Parliament. The President, the Article 324 says, shall make such staff available to the Election Commission to discharge the functions conferred by the Constitution. Look at it now. Now the question you may ask, so when the Election Commission makes a request, then the President should come to serve the request of the Election Commission. It is the order of the Constitution. We have to do it. So whenever the Election Commission makes a request, then the President cannot say no to that. The President cannot ask for postponement of the election. He is bound by that. For example, the President's election is going to be held. It is a work to be undertaken, to be discharged by the Election Commission. And he will come and say that, yes, from next month onwards, I am going to initiate the process of election to elect a new president. No president can differ with that. And he has to serve to the request of the Election Commission. Here is a case, the Election Commission stands taller than anybody else. And then if you come to Article 326 we already discussed about the adult suffrage. After 18 years, everybody is having a right to vote, whether you are male or a female, or if you are adult above the age of 18 years, you are entitled to vote. I already mentioned that we stand taller than US Constitution and United States of America in giving equality. I do not want to go once again due to the passage of time. Then Article 361, immunity, given to the President of India and also the governors of states. See, if a President of India or a governor are doing their work, discharging their duties, official duties, then they cannot be summoned to any court. Therefore, Article 361 gives them immunity, saying that President of India or the governor shall not be answerable to any court. One. And then it also says that civilly, criminally, they're all immune. If they do any work as a part of discharging their official duties in exercise of the power, then they cannot be unnecessarily summoned to the court. This is made with great care. This I can tell you, if a president is coming to court or a governor is coming and standing before the court, what will happen? The president's counterpart in US or in UK is calling him, and then the message is given saying that my president has gone to court to answer a summon. What will happen to the reputation of the country? Therefore, with the great care, this has been made. So 361 gives immunity civilly, criminally to the both president and the governor. Then coming to Article 368. 368, I will say only one thing, that Article 368, in fact, I want to discuss this, but due to the passage of time, let us end. Here, with this 368, you must appreciate one thing, that Parliament is given enormous power to make laws, no doubt. They can amend the Constitution. But look at the great acumen, the great foresight, the wisdom the founding fathers have kept in their mind, they used at the time of drafting the Constitution. While amending the Constitution, nicely and fortunately, they were not given to any individual. For example, had the founding fathers given the power of amending the Constitution at the hands of few people, for example, I am giving to the Prime Minister, I am giving to the President, single person, I am giving to the Council of Ministers, what will happen? What is happening in the Parliament, nobody will know. Anything will happen. One person will rewrite the entire Constitution. Today, this democratic country will become non-secular. Today, the secularistic country will become non-secular. Today, the democratic country will become autocratic country. Today, a republican country will become a monarchical country now. So therefore, with all care and seriousness, the founding fathers of the Constitution have drafted Article 368, saying that the amending power of the Constitution has been given only to the Parliament. Friends, with all these things, in fact, I must tell you only one thing, that when the Constitution fixes the age limit for people to contest for MPs and MLAs elections, it should also fix up the outer time limit for their contest. It is also one of the Lacunae, but we can keep on discussing all important aspects, but due to the constraint of time, let me end saying that with a concluding message, that we have many beauties, many wonders, many phenomenal charms in our Constitution. To make it fulfill, we have to see that at the school level, at the college level, the Constitution of India should be made as a compulsory syllabus, so that the future generation will be better advised that what are the rights available to them, what they should do, and what they should not do. With that, I thank the organizers for having given me a very nice opportunity to share some of my views on the topic. Thank you very much.
Thank you very much, sir. In fact, a presentation which has almost covered all important articles of the Constitution of India, that adds what I say, that a flavor to the Constitution, not all the provision. Those provisions which act as the special provisions, which are the beauties of the Constitution, have been called out extremely well by your Lordship. We are very much thankful for your Lordship. And some of the provisions are something very strange to us, and we feel, to be frank with you, we feel ashamed of not knowing it already. For example, Article 262 of Plus 3, enforceability of judgment through the country, is something even civilized do not know. I am very much thankful, Lordship, for having a deep insight about how a judgment of the court can be executed through the India. We thought EP is only under the CPC. Now we come to know that the power of the courts to execute a decree through the country lies in the Constitution of India and not only in CPC. Such great insight is something very appreciable, Lord, and we are very much thankful for the Lordship's insight. And we know how deep the Lordship has got knowledge about the Constitution of India. And we thank you, Lordship. And there are some comments in the chat box. I read it, Lord. Some of them are appreciations. And one, Tony from Miranda has stated that our nation includes me, and we were woefully ignorant of the provisions of the Constitution of India. Thank the Honorable Justice and the organizers for throwing a clear awareness of our splendid law called the Constitution. Pray that this lecture reaches the mass through the country. And she's very much indebted to Lordship's lecture. And we'll have another comment from Mr. Saravanan. As your Lordship rightly said, when every citizen speaks about the fundamental right, they should fulfill their fundamental duty also for the development of the country. Every citizen, including President of India, is bound by our Constitution. It's an honor to have to participate in the webinar and thank the Honorable Lordship. And most of them are very much impressed over the way in which it is being presented today. Shanta Kumari said covered important articles, particularly Article 3, and Murugesan, thank Lakshmi for your fantastic presentation and to all persons concerned, and systematic presentation of the articles of the Constitution with suitable examples. Kudos to Honorable Judge, the organizers, Mr. Raghavan. And Millard, there are some questions posed to me, 4 or 5 questions in the chat box. May I read it out, Millard?
Yes, yes. Yes.
First doubt is whether act of the state government, which is included in Schedule 9, is outside judicial review, or any law included in Schedule 9 can be reviewed by the court. But a judicial review can be exist for the subject matter of acts in the Schedule 9 also.
But there are petitions pending in the Supreme Court today on this issue. Let us not comment on that.
Yes,
there are
sub judice.
They are challenging the inclusion of some of the laws in the 9th schedule.
So, yes. Millard. Then, Millard, next question is whether power of judicial review makes the judiciary having an upper hand over the other 2 wings of the government.
It cannot be viewed that way. Yes. See, it can never be viewed that way, because judicial review, how do you say that? For example, I'm just telling you a small example. Article 79 says that there shall be a parliament. There shall be a parliament. If the government wants to create another parliament for east, south, north, but how this is possible now? So therefore, when the complaint is brought to the Supreme Court, they have to answer it now. So answering question against the government, you can't mistake that it is exceeded the limit. Yes. So it is, we are there, the judiciary is there to balance, to answer some of the questions. So see, sometimes, we have seen that in Sangari Prasad, one view is taken, in Sajan Singh, another view is taken, Golaknath said both Sangari Prasad and Golaknath are wrong, the Sajan Singh are wrong, and then the Kesavananda Bharati comes and says that Golaknath is wrong now. So the views are there, but sometimes the views are given only on a particular situation. Therefore, you can't say that it is wrong. Ultimately, it can be resolved. Yes.
Next question is whether the doctrine of checks and balances in US Constitution is also available in the Indian Constitution.
Yes, we have, because see, it is not there in the Constitution, but after interpretation of the Constitution, in one of the one of the judgments, the Supreme Court has ruled that the separation of power is a basic structure of the Constitution. As a result, the judiciary can interpret the law but cannot create the law. Yes, if judiciary creates a law, then you are doing the work of executives, legislatures. That is not permissible there.
Yes, sir.
Yes, it is there.
Then, my lord, next question is, how do you view judicial activism within the 4 parameters of the Constitution? Whether judicial activism is a power under the Constitution or it's only an extra constitutional power? Very controversial question.
See, judicial activism, see, we have been seeing the PIL's roll file when responsible citizens are coming to the court seeking some answer. The Supreme Court gives an answer, and this has been taken as the judicial activism. It's all looking, it all depends upon the beauty is not in the flower, but only in the eyes of the beholder only.
In the fragrance of the flower.
Yes.
Yes, sir. Next question is, what is the fate of the right to property? It was initially under the fundamental right. Now it is relegated to an ordinary legal right. Does not the right to property in the...
It's not ordinary. It is because, see, the right to hold, acquire and dispose of the property was originally enshrined in Article 19(1)(f). Now what happened? It has been taken out by the Janata government in 1979 and kept in Article 300A. It is only a constitutional right. It is not a legal ordinary right. It is a constitutional right. And then, see, it is not a fundamental right, but it has become a constitutional right. See, many views are there saying that we should be given, the citizens should be given some inalienable rights. Originally, the constitution makers, the founding fathers of the Constitution, they thought fit that at least some rights, basic rights, which are inviolable, inalienable rights, should be given to them, which cannot be taken back under any circumstances. But this has been taken. However, this is not completely taken out from the Constitution. It is there, still in the Constitution. Therefore, you are enjoying the Constitution right. It is still there. So they cannot just like that deal with their property. They have to answer to the Constitution. Article 300A is there. Therefore, they cannot deal with the property just like that. So you have a constitutional right. You have constitutional argument. You can go to court and you can preserve the right, preserve the property.
Yes, Miller. Next question is regarding Article 142. The person asks whether an order passed by the Supreme Court under any other order passed by the Supreme Court is having a nature of a direction only, not a judgment reflecting the merits. Can it be said to be a binding precedent under Article 141 if a direction is passed under Article 142? A direction under Article 142, can it take the place of a judgment or a law of the land under Article 141?
Definitely. See, any order is passed while disposing of specially petition under Article 136, the order will be getting the protection from Article 141. Because whatever the order, whatever the degree, whatever the judgment is passed by the Supreme Court, it is only under Article 141 saying that all the courts below are bound by that.
Yes, ma'am. And next question is about Mr. Raghavan. Right to get a speedy justice is one of the right or mentioned in the part 4. Whether it can be made mandatory by making laws to speed up the justice delivery process to avoid a lengthy, protracted hearing. Can there be a law to speed up the justice delivery process?
See, basically, education is more important here. I mentioned to you that education should have been, right to education should have been made as one of the fundamental rights in the year 1949 and 1950. Had it been there, perhaps the people would be aware of the value of time. And whenever any litigant comes to the court, they will come prepared, and then they will take only a specific time limit, and then they will enable the other matters to be disposed of. Today, you know that, see, they are filing the petition, they go away, so the matter is taken up, adjournment is taken, and then they argue the matter for 2 days, 3 days. After third day, they take out time. And therefore, see, basically, if persons are all fully educated about the rights of your life, your valuable rights, as well as the rights of the other people, this problem could have been easily sorted out.
And the final comment says, within the available short time, the Lordship is able to throw much limelight on the important aspects of the Constitution of India. As the Lordship said, the beauty of the Constitution lies in the articles. The articles can be compared to the flowers of the tree, and the fragrance is the beauty, and the fragrance has been brought out well by your Lordship. So we are very much benefited. It's one of the comment given by the one of the participants that reflects our mind also. So on behalf of Hemalatha, my co-host, representing Lex Webinar Series, we wholeheartedly thank your Lordship for the wonderful, insightful session by just glancing very important provisions and articles of the Constitution that has brought out the real beauty of the Indian Constitution of India.
Thank you so much.
So, thank you very much. Thank you. Thank you. May I sign up, Lord? Yes.